Hi everyone, welcome back to the Communication and Conflict YouTube channel, promoting mindful communication and growth through conflict. So this is the second of 3 videos that I'm making about mediation, which is what I practice. I've been a mediator for 23 years and a conflict coach, and I also train mediators and conflict coaches. And the first video was about how does mediation help people to resolve conflict. So you may have seen that already. If not, there'll be a link in the information below about how you can go and see that. And this video is about what a mediator does, or what does a mediator do and why. So I'm going to describe what I do as a mediator. You may sometimes find that mediators practice in different ways. So all I can do really is explain what I do as a mediator and why, and what the thinking is behind the mediation process which the mediator is providing, and how it's different to most other approaches to dealing with a conflict. So different to, for example, what a judge would do or what an arbitrator would do, and why that makes a very, very important difference to the purpose of the process, and therefore how it's carried out and how I conduct myself within the mediation. So there's kind of going to be 3 main parts to it. There's going to be looking at that, why what a mediator does is different to a judge or an arbitrator and what the significance of that is. I'm also going to try to explain a bit more about how I conduct myself, how I communicate as a mediator, in order to kind of keep in line with the purposes of the mediation process, so why I do things the way that I do them. And then I'll also talk a little bit more about, which I think I talked a little bit about in the first video as well, but a little bit more about the thinking behind confidentiality and how that ensures that the process is a without prejudice process, which again I'll say a little bit more about when we come to that section. But the without prejudice aspect, or the status of mediation being without prejudice, is very important to and significant for why it helps people to resolve conflict effectively if they're involved in other kind of adversarial processes otherwise and they want an alternative to that. So that's what we're going to look at, and I'll go through it, and as ever, if you've got any questions or comments, please put them in the section below. But we'll get started on that just after this. So, what does a mediator do and why? And as I said, the thing I want to discuss first of all is how a mediator is very different as a role, takes a very different role to that of a judge or an arbitrator, or it could be somebody on a panel in a tribunal or a hearing or of a grievance procedure or something like that, where the people involved in that kind of situation will hear about the problem situation that both or all parties are bringing for discussion, and they'll be expected to give a view about it. So they'll assess it and they'll give a viewpoint about it. So the third party in those situations gives a viewpoint. And so therefore the process is intrinsically adversarial, because if you're one of the participants and you are unhappy with what the other person's done in a situation, whether it's in the workplace or in court or something like that, you'll want to persuade the third party that you're right and the other person's wrong, or that you're the victim and the other person's the perpetrator. And likewise, the other person will want to do the same about you, because they'll want to persuade me, if I'm the third party, that they're right and you're wrong, because I'm going to give a viewpoint about it. So you're going to want to make your case to me to persuade me that you're right and the other person's wrong. So that's whether I'm a judge or an arbitrator, or I'm on a panel, on a hearing or something like that. So therefore, it's intrinsically an adversarial process. It means the aim is that there's a winner and there's a loser. There's someone who's right and someone who's wrong. And as I explained on the first video, in a lot of situations, it's very unlikely there's ever going to be an objective basis to come to that decision, unless someone's broken the law or broken some kind of legislation, in which case it's appropriate that it goes to an adversarial process. Then in a lot of workplace disputes or neighbour disputes or complaint situations, there may not be any law or legislation that's broken, so there won't be a right and a wrong, a victim and a perpetrator. There'll just be a breakdown in the relationship, or a breakdown in communication, or an unresolved conflict of some kind. And so an adversarial process is inappropriate in those situations. So that's when they would come to mediation, where people could use mediation to try to resolve that difficulty. And therefore it's important that the mediator doesn't give a view. So my role is never to give a viewpoint, because otherwise, as I say, it's back to people trying to persuade me that they're right and the other person's wrong. And so I always make it clear to people in mediation that that's not my role. My role is to help them to have a conversation, to have an effective conversation, to structure the meeting in such a way that supports that. And that's what I'll go into more detail about in the third video, is how a mediation meeting is structured, as well as what I do when I meet people separately. But my role, as I say, is not to give a viewpoint. So therefore, it kind of releases people from having to try to persuade me that they're right and the other person's wrong. You know, I might have a view about it, but it's important that I don't give that view, because otherwise I will cease to be seen as impartial. So, for example, if I were to give a viewpoint, then it might immediately mean that it's a viewpoint that one person likes and the other person doesn't like, in which case I'm no longer seen as being impartial in the situation. If I start to do things like give advice or make suggestions, the same thing can come across, because people one person might like my suggestion and the other person might not like my suggestion, in which case, again, it's as if it's now two of us against one, so it's no longer an impartially facilitated meeting, because I've given a view about things through my suggestion. So it's really important that as a mediator, I don't give advice, I don't make suggestions, I don't ask questions that try to lead people to where I think they should go, and I don't express an opinion. And often that can be quite a challenge for people training to be mediators, but that's part of what the discipline of being a mediator is about. It's being able to kind of help people to have a conversation, to listen to what they say, but not to start thinking that they need to hear my view about it. And as I say, what that does is it releases people to be able to have their own conversation. They're not always having to try to persuade me. They know that I'm there to support them in having a conversation, but I'm not there to take their side for either of them, either for them or against them. So that builds a lot of trust in people when they come to mediation, because they know that I'm not sitting there in judgment. And when we talk a little bit later more about confidentiality, it's why, because I'm not judging them and I'm not going to share what I hear in the meeting with anybody else, it means they can have a very open discussion with each other. And I'm not going to be coming in, judging them, giving a viewpoint, and they're not having to try to monitor what they say so that I might not approve of them. They can say whatever they want, as long as they're not being abusive or talking over each other. And so this is where a lot of the strength of mediation comes from, in that there's a third person present in the meeting to help the conversation to go forward, but that person isn't trying to sway people one way or the other. So they don't really have to worry about me and what I'm going to contribute. They're more able to focus on what they want to say to each other. And that can make an enormous difference to how their conversation goes compared to perhaps how it's gone when they've been falling out with each other, because there's not been someone to try to kind of keep it on track to ensure that people are giving each other space to talk to each other, which is another one of the things that I will do through one of the two ground rules that I establish in the meeting, which is that people don't interrupt one another, or that we all don't interrupt one another, and there's no use of abusive or offensive language or behaviour. So this that kind of aspect of me not giving a viewpoint about things is, as I say, a very important distinction between my role as a mediator and the role that someone would have as a judge or an arbitrator, or somebody on a panel in a hearing, perhaps in a grievance procedure or something like that. So yeah, I'll leave it at that for this section, and we'll move on to looking at the actual skills and practices that I use in order to communicate and conduct myself as the mediator to ensure that I'm able to maintain that role of being an impartial facilitator of the meeting. How do I conduct myself as a mediator? What communication skills do I bring to the process to ensure the impartiality of the process, the creativity, the supporting of more effective communication, the supporting of mutual and self-understanding? What are the different things that I do as a mediator that are designed to support that being possible? So often I'll say to people on a training course, in a way, all you do as a mediator are three very simple things. We listen, we summarize, and we question. But what matters is how we listen, summarize, and question. So I will listen to people, whether I meet them individually before a joint meeting or during the joint meeting. What I might do is sometimes take notes about what they're saying, but what I will always do is summarize back to people what they've said in their words. So I will always use their words when I summarize back. I don't change them to my way of saying things. I don't try to kind of miss things out or what some people call reframe what people say. And the reason that I do that, the reason I summarize back to people what they say in their words, is so that in a way they can hear themselves, so that they can reflect on how they're expressing themselves, so that they can reflect on how they see the situation, not how I see it, but how they see it, which is why I stick to the words that they use. I do my best to do it. I don't remember it 100%. I do my best to remember as much of what they say, but what I really focus on is using their words when I summarize back to them. And what that can often do is help people to think more about what it is they're actually saying they're bringing, or what they're experiencing in the dispute. Quite often when people are caught up in a dispute or a difficulty of some kind, conflict and a relationship breakdown, they're so kind of mixed up in it, they're so confused by it, they don't get a chance to look in on it and reflect on it. And that's what the purpose of listening and summarizing does for them. It gives them a chance to kind of stand back from their difficulty and hear themselves and think, okay, yeah, I can see it differently now. I can see how I'm saying things. I can see how upset I am by things. And that in itself can be very powerful for people, because they very often don't get listened to. What people will often get is people saying, they won't hear any kind of summary back. They'll just hear people saying, oh, you should do this, you should do that. Oh, you don't want to do that, you don't want to do this. And the whole point about mediation is it's a safe, creative space to be able to say what they're unhappy about, and then simply to be able to reflect upon it without any kind of input from anybody else trying to tell them what they should do, what they shouldn't do. So that's one of the other reasons why I don't give opinions or advice, because I don't want to complicate things for people by adding my, useless and irrelevant kind of input to it, because I'm not the one who's going to go on and live their life after the mediation. My sole focus is on helping them to understand themselves. So listening and summarizing are two very important practices as mediators, and one of the skills of a mediator is to be able to keep that discipline of not trying to change what people have said. So that might sometimes mean that they see some quite kind of difficult language, some quite fruity language, as it might be described. But so long as that language isn't a directly abusive comment about the other person, if it's in the joint mediation meeting, then I would summarize it back. because it is how they're expressing themselves. And they may then decide, oh, I don't really want to say it like that, I want to find a better way of saying it. But I will always summarise back to people what they've said in their words so that they get a chance to hear themselves. So that's listening and summarising. And then the other practice that's important that I said about is questioning. So a mediator will always ask questions, but the important thing is that those questions have to be open questions. They have to be questions that are not trying to lead people to where I think they should go, because again, that's like me giving an opinion or giving advice. My questions are always to try to, again, help the person to reflect on what's happened, how it's affected them, what they'd like to be different, how that might be possible. So those might be the kinds of questions I even ask people. I might say to them, so, what is it you want to happen in this situation? What would make things better in the future for you? You've said these things, which I've summarised back, are the problems. What would you want to be different? How might that be possible? How could that come about? What if it wasn't possible? What else might work for you? How would you feel if it did get sorted out? How would you feel if this situation was improved? What might be the obstacles to that happening? So all these kinds of questions are designed to help the person to reflect on their difficulty and then to be creative in moving forward in their situation. So that's always the focus. The only thing mediation can ever provide is help with people to create a different way forward to the one which is presently not working for them. That's all it's for. That's the only purpose of it. It's very, very simple. But the challenge for a mediator is not to think that they're going in to fix it for people, because I'm nothing to do with people's situation after the dispute, after the mediation is over. They need to be able to go away confident that they've created a better way forward for themselves, because I won't be there to monitor it, to police it. It's got to be them that takes responsibility for creating that way forward. So everything that I do is about being focused on supporting that possibility. So in many ways, that's all I do as a mediator. I listen, I summarise, and I question. Obviously, apart from all the kind of the arranging of the meeting and the kind of administration of things, obviously I'm responsible for. But in a way, you can't define that because that's going to be different for every case. But the actual practices and conduct that I have within the mediation itself that provide and ensure the mediation process moves forward effectively are to listen, to summarise, and to question. And confidentiality is something that we'll talk about in a little bit. But effectively, as I say, that's the purpose, that's my role, that's the challenge for me. And while I portray it as if it's very simple, when people train to be mediators, one of the biggest challenges they ever have is to be able to create open questions rather than fixing leading questions. That's always the biggest challenge of being a mediator, because it brings in, we're often tempted to do what in mediation we call rescuing people, to try to fix things for them, which I've explained quite often now isn't going to be effective for people. They've got to be able to create their own answers to a situation. So that's that section. That's how a mediator conducts themselves and why, how I communicate and why I do things that way. So next we're going to move on to looking at the without prejudice status and basis of mediation and how my conduct ensures that that's possible. So the final part of this video about what does a mediator do and why is about the without prejudice status of the mediation process and what I do to ensure that that status remains in place.
So without prejudice, effectively the meaning of that is that mediation is a process which doesn't affect other processes. So it's not going to influence, say, if there's another adversarial process going on at the same time. Whatever gets discussed in mediation remains separate from that and can't be drawn into discussions about other things. And the reason that that's important is that it means that people can turn up to mediation safe in the knowing that they can have an open and frank discussion about the difficulties concerned and then not have that used against them. And the way in which I ensure that that's possible is that I don't share anything that I hear in a mediation outside of the mediation with anybody else. So I keep everything I hear confidential. I don't keep notes about what's been said in the meeting. So there aren't like minutes written up afterwards or a report about the meeting sent to anybody, and no record is kept of it. It may be that during the meeting, the people themselves, the participants in the mediation process, decide that they want something to be recorded as an outcome of the meeting. So it might be they come to agreement about something and they want it written down. Although, as I said in the first video, in the kinds of mediations that I'm involved in, it's actually quite rare that people want something written down. There are a lot of approaches to mediation that seem to think that's the only purpose of mediation, but actually a lot of the time people don't want agreement. They just want to be able to kind of feel that they can sit in a room and have a constructive conversation with another person about the things they're concerned about, and they don't need to have everything recorded afterwards. As you know, most of us can get along with other people without having to have everything written down all the time to say we agree to do one thing or another. We can just trust that we can have a working relationship with someone, or a personal relationship with someone that doesn't need everything to be written down. So, but if they do want something written down, that would be an outcome of the meeting. But I would only ever share that with the people involved in the meeting. So I wouldn't send it to anybody else, so that then it's up to them to decide what they then do with that. But I would never be called upon or wouldn't speak about what I hear in a mediation meeting because it's without prejudice. So the whole point of it is that the content of it doesn't get shared anywhere else. And mediation anyway is recognised as being a process which the content of which can't be called upon in adversarial processes because it's without prejudice. So you won't hear of the content of a mediation being called upon to be shared in court because it's recognised as a confidential discussion. Or in other hearings, what gets discussed can't be shared by me to other kind of forums. So they might request it of me, but I would turn it down. I can't stop what participants choose to share outside of the mediation. That's up to them to decide. But the point is, I wouldn't verify it. So it would just be their hearsay, effectively. It would just be their point of view. So I wouldn't confirm or refute anything that's claimed to have been said in a meeting. So therefore, that keeps it as a without prejudice process, because obviously people could say whatever they want to say about what hasn't been said in a meeting, but if no one's there to confirm it, then obviously that means that it's just their view rather than an actual verified fact that something has been said. But the point of the mediation process anyway is that the intention is that that doesn't then happen after mediation. The aim of it is that people are creating something that then works for them, so there's no need for them to try to use what's been said in the meeting against the other person in any other forum. The aim of it is that they're able to resolve things amicably and constructively and with a view to things moving forward in the future. And, you know, that is the basis on which it works. And for 23 years, that's how I've been providing mediation. And that is the case. It isn't something which leads to people trying to use what's happened in mediation against people in another context. Or through another process like a grievance procedure or some other kind of adversarial process. So that's the kind of without prejudice basis of mediation. And as I say, the way that I ensure that that's maintained is that I keep anything that I hear confidential. I don't record anything. If I make notes in the meeting, it's only to help me remember what people have said. It's not as a record of the content of the meeting or the discussion. and the only thing that would get written down would be what the participants themselves create together. So it can only be what they both agree on that gets written down, and I would only share it with them afterwards so that then they can decide what they want to do with it. I wouldn't share it with anybody else. Even if the participants asked me to, I would say to them, it would be for you to share with whoever you feel is appropriate, but I don't do that. Now that, some of these practices might be different to what other mediators do, but I do it for a very clear reason. And I'm kind of unsure sometimes how mediators do things to keep in line with without prejudice status of the process, if they do things differently to that. But obviously that's for them to explain and decide. But that's the kind of the final thing that I would say about my conduct as a mediator, what I do and why. And so, as I've said, the next video will be about the actual structure of the joint mediation meeting, and I'll also probably say something about the initial meetings where I meet people individually as well, and what the purpose of those are, so that then hopefully the 3 videos together give you a kind of good and hopefully useful overview of what mediation is, why it's done the way it is, how it differs from adversarial processes, and why it can be immensely useful for people in finding a different way forward that works, instead of spending their time trying to kind of defeat the other person in contexts where that's not appropriate and is very unlikely ever to be a useful way forward for them. So I'll end it here. I hope you enjoyed it. Please like the video if you did like it. Please put any comments in the comments section below. Also, please, if you've got other requests or other things related to communication and conflict resolution that you think I might be able to do a video on, then please ask for that, and I'll do my best to provide it. We'll come to an end here, and I hope you enjoy the next video, which, as I say, will be about the structure and of the different aspects of the mediation process. Thanks for listening. Goodbye.